Welcome to the course on medical law. This lecture is on surrogacy regulation in India. The concepts covered in this lecture are surrogacy, altruistic surrogacy, commercial surrogacy, Surrogacy Regulation Act of 2021. We will also be discussing about the key features of the legislation and the lacunas in the law. Then we will discuss about the recent judicial development with regard to surrogacy regulation in India. The keywords of this lecture are surrogacy, motherhood, surrogate mother, gestational surrogacy and surrogate child. We have seen the various aspects involved in surrogacy, that is the ethical, medical and legal aspects with regard to surrogacy. India has very recently enacted a law on surrogacy after a very lengthy consultation process and deliberation. So, it is important to discuss and understand the intricacies of the law for a better implementation across the country. So, in this lecture, we will deal with the laws related to surrogacy. We will also be discussing about the historical development of the law on surrogacy in India. Surrogacy is actually a second opportunity to enjoy the parenthood for infertile couples who cannot have a child. It is an accepted practice across the world and also in India and has been practiced for a long time. It is an alternative for childless couples who do not want to opt for adoption. Surrogacy falls into two categories. One is of commercial nature, second one is of altruistic nature. Altruistic surrogacy involves the surrogate mother receiving no financial compensation while comparing with commercial surrogacy. Commercial surrogacy implies that the surrogate mother or the person who is involved will be making a profit by compensating the surrogate mother for having the kid. Due to the absence of legislation, the practice of surrogacy was unregulated in India for a long time. So, the commercial surrogacy was also happening in India without any restrictions. Surrogate mothers were exposed to a variety of health risks and types of exploitation due to this lack of legal protection. So, it generally means that surrogacy can be easily divided into two different types of surrogacies. One is commercial surrogacy, where the surrogate mother will be getting some financial benefits by participating in the endeavor. Whereas, in case of altruistic surrogacy, the participation by the surrogate mother is purely because of altruistic nature and there will not be any commercial transactions. But however, sometimes medical expenses would be covered by the parents of the child. Commercial surrogacy was for some period unregulated in India. During this period, the business of commercial surrogacy was flourishing and there was large number of underprivileged women who were eager to make a fair living by renting their wombs. It has grown to be a multi-billion-dollar industry which led to lot of problems and disputes. This caused problems especially for women physically, mentally and also financially. Child trafficking also increased because of surrogacy. Surrogacy also made babies seem like things that people could buy, which raised ethical questions. So, apart from legal issues, there are also a lot of ethical issues involved in surrogacy. So, unlike materialistic things, human beings cannot be seen as something which could be sold or bought. So, there was also some serious ethical considerations about the commercial transactions which were involved in surrogacy. The demand for legal regulation and control of the practice of surrogacy came from different platforms, from medical practitioners to feminists, public health scholars, activists and different stakeholders were calling for legal regulation with regard to commercial surrogacy in India. Several efforts have been undertaken in this area, including the National Guidelines of the Medical Council of India, the report of the Law Commission of India, various government notifications governing surrogacy, but none of them were totally effective. There was a legal lacunae because there was no proper legislation to address the issue of surrogacy. Surrogacy has this peculiar problem. Surrogacy is needed because there are a lot of parents who doesn't have children, but at the same time commercial transactions for the purpose of surrogacy cannot be allowed. So, a law was required to adequately regulate the surrogacy related practices in India. In the end, after numerous efforts in order to protect vulnerable women and address legal lacunas, the central government introduced the Surrogacy Regulation Act of 2021. Now, let us discuss about the Surrogacy Regulation Act of 2021. The Surrogacy Regulation Act is a comprehensive framework covering all facets of surrogacy. The Act intends to stop child abandonment, including abandonment after surrogacy, which were on rise in India. So, there were several scenarios where there was some agreement that the parents will take care of the child after the delivery by the surrogate mother, but subsequently there were several cases in which the child was abandoned after the surrogate mother delivered the baby. So, the purpose of this legislation is to stop child abandonment and make it a legal requirement for the persons involved to take care of the child after its birth. It also attempts to end the exploitation of women and restrict intermediaries who import human embryos and gametes. Since India had learned the lesson from unregulated commercial surrogacy, the Surrogacy Act of 2021 only endorses gestational surrogacy with altruistic purposes. So, 2021 legislation expressly prohibits commercial surrogacy. So, all commercial transactions for the purpose of surrogacy are not valid in India and is a punishable offence, whereas surrogacy with pure altruistic motive is promoted under the 2021 legislation. The Act intends to make commercial surrogacy, which involves selling and purchasing a surrogate services in exchange of money, as illegal. So, commercial surrogacy is completely illegal. The Act provides for constitution of central and state surrogacy boards to regulate surrogacy in India. So, the Act provides for constitution of institutional framework for the purpose of regulating surrogacy. So, accordingly, there will be a central board at the central level and also a state board in each of the state to regulate practices associated with surrogacy. The Act also comprises or constitutes certain offences like prohibiting commercial surrogacy, exploitation of surrogate mothers and children born out of surrogacy. So, any person who is acting in contravention of these provisions will face punishment which is of penal nature under the 2021 legislation. Now, let us see what are the key features of the legislation. Altruistic surrogacy is specifically defined in section 2(1) clause B of the Act. It means that surrogacy in which no charges, expenses, fees, remuneration or monetary incentive of whatever nature other than medical expenses is involved. So, this means that if there is no charge, no expense, no fees, no monetary incentive involved in surrogacy, then it will be considered as altruistic surrogacy. But the parents are allowed to cover the medical expenses. So, apart from medical expenses, there should not be any commercial transaction with regard to surrogacy. Commercial surrogacy is defined in section 2(1) clause G of the Act. It means surrogacy in which selling, buying or trading the services of surrogate mother by way of giving a payment, reward, benefit, fees, remuneration or other monetary incentive. So, if there is any financial payment, reward, benefit, fees, remuneration or monetary incentive, then it will be considered as commercial surrogacy. Here we have to note that commercial surrogacy is prohibited under the legislation, whereas altruistic surrogacy in accordance with the regulations is promoted. Now, let us see the definition for intending couple and intending woman. Intending couple is defined under section 2(1) R of the Act. Intending couple is going to be the prospective parents of the baby. It is defined as a couple who have a medical indication necessitating gestational surrogacy and who intend to become the parents through surrogacy. So, intending couple will become the parents of the baby after its birth. Intending woman is defined in section 2(1) S of the Act. Intending woman is an Indian woman who is a widow or divorced between the age of 35 to 45 years and who intends to avail surrogacy. So, intending woman means a woman who was previously married, either she is a widow or divorced, and she should also be between the age of 35 to 45 and now intends to avail surrogacy. So, this means that a single woman may, in accordance with the situations given in section 2 clause 1 clause S, can become an intending woman and thus became the parent of a surrogate child. Now, let us see the definition of surrogate mother, which is defined in section 2 clause 1 ZG of the Act. Surrogate mother is a woman who agrees to bear a child through gestational surrogacy for altruistic purpose. So, there are two things here. One is that surrogate mother is the person who is going to give natural birth to the baby, but it should be only for altruistic purpose. If there is commercial intent, then she will not become a surrogate mother and such kind of activities are prohibited under the law. But if it is purely for altruistic purpose, the person or the woman who agrees to bear the child through gestational surrogacy will become the surrogate mother under section 2(1) ZG of the Act. Now, let us see section 3, which deals with prohibition and regulation of surrogacy clinics. So, one of the important purpose of this legislation is to regulate the activities associated with surrogacy. So, where does the activities take place? It happens in surrogacy clinics. So, section 3 specifically deals with the prohibition and regulation of surrogacy clinics in India. According to the Act, surrogacy clinic must be registered under the law before it can conduct, associate with or support surrogacy related activities and treatments. So, previously we have seen the legal regulations with regard to operation of a clinical establishment in the country. So, we have seen the different laws that an establishment has to follow in order to start healthcare service providing. But apart from all this, if the clinic is planning to do any service which is associated with surrogacy, like conducting it, associating with it, supporting it or any other surrogacy related activities or treatment, then they have to register themselves under the 2021 legislation. The Act also prohibits promoting, advertising or doing anything that might encourage a woman to act in the role of a surrogate mother. So, there should not be any incentivizing factor for a person to become a surrogate mother other than pure altruistic motive. So, if a clinic is doing anything like promoting or advertising which will entice a woman to become a surrogate mother, then that is prohibited under the legislation. Surrogacy clinics shall not cause abortion during the period of surrogacy without the written consent of the mother and authorization by the appropriate authority. So, even abortion during the surrogacy period is restricted under the legislation. For the purpose of abortion of the baby, the consent of the surrogate mother, which should be in written form, and also an authorization from the appropriate authority is mandatory under the legislation. The clinic engages in the procedure of surrogacy shall not indulge in sex selection of the fetus. We have already seen that sex selection of the fetus is prohibited in India. It is also a punishable offence. So, the clinic who is engaged in the practice of providing services associated with surrogacy shall not indulge in the sex selection of the baby. Regulation of surrogacy and surrogacy procedures is given under section 4 of the legislation. The act allows only surrogacy for gestational surrogacy, that too only for altruistic purposes. So, there is an express prohibition in the legislation that no clinic shall perform commercial surrogacy. The section states that the following conditions shall be fulfilled by an intending couple. So, a couple who is going to be the parent of the surrogate child after its delivery by the surrogate mother shall be fulfilling these conditions. The couple shall be of Indian origin. So, it is mandatory that the couple shall be of Indian origin. They shall be legally married between the ages of 23 to 50. So, this means that they have to be legally married between the ages of 23 to 50 for males and between 26 to 55 for females. They shall not have a surviving biological, adopted or surrogate child and must obtain a certificate that indicates the necessity of gestational surrogacy. This is also another requirement. They shall not be having any surviving biological, adopted or surrogate child and also should obtain a certificate that indicates the necessity of gestational surrogacy. This is also mandatory. Section 4 clause 3 clause B also provides for the eligibility criteria of a woman who intends to become surrogate mother. So, the legislation also provides the criteria that has to be fulfilled by a woman to become the surrogate mother. The person has to be married. So, only a married person will be eligible to become a surrogate mother. They should have at least one child of her own. This is also mandatory. Must be between the ages of 25 to 35. Must not be mentally or physically challenged. So, these are the 4 mandatory conditions with regard to a woman who is intending to become a surrogate mother. She shall be married, at least has one child of her own, must be between the ages 25 to 35, must not be mentally or physically challenged. An intending couple shall get insurance coverage of such amount in such manner as may be prescribed in favor of the surrogate mother for a period of 36 months covering the postpartum delivery complications from an insurance company. So, as I said in the beginning of this lecture, the legislation has some specific provisions to protect the interest of the surrogate mother. So, the law requires that the intending couple should procure an insurance which shall have adequate coverage to ensure that the postpartum delivery complications for a period of 36 months will be covered under the insurance policy. It is stipulated that the voluntary informed consent is mandatory and to be taken before proceeding with the surrogacy procedure. The voluntary informed consent of the surrogate mother is mandatory and it has to be taken before proceeding with the surrogacy procedure. The legislation also speaks about the right of the surrogate child. The act mandates that the intending couple or the intending woman shall not abandon the child born out of surrogacy procedure for any genetic defect, any medical condition, sex of the child, conception of more than one child, etc. This is provided in section 7 of the legislation. So, there were several scenarios before the coming into force of this legislation that the surrogate child was abandoned by both the parents and the surrogate mother after its birth. So, this legislation has provisions to ensure that the child's interest will be taken care after the birth. So, no child who is born out of surrogacy, that is the surrogate child, shall not be abandoned for any genetic defect, any medical condition, sex of the child, conception of more than one child. The child born out of surrogacy shall be deemed to be the biological child of the intending couple and be entitled to all rights and privileges under the law for the time being in force. So, this means that after the birth, the surrogate child will be considered as the biological child of the intending parents, and the child will be entitled to all rights and privileges under any law for the time being in force. So, the child will be considered as biological child of the intending parents, and the child will be entitled to all the rights and privileges like a child which is born out of natural birth. Registration of surrogacy clinic is provided in section 11. The act requires that in order to provide the service of surrogacy, the clinic must first get itself registered. So, registration of a clinic which is intending to practice or provide surrogacy related service is mandatory under the legislation. The application for registration shall be made within 60 days of the appointment of the appropriate authority. The clinic registration will remain valid for 3 years and the clinic shall file an application to register again. So, initially the registration will be valid for first 3 years and then again it has to be re-registered by filing an application. The act provides for establishment of national and state surrogacy board. So, as I stated in the beginning, the legislation provides for creation of an institutional framework to regulate surrogacy assisted practices in India. So, section 17 and 26 provide for the establishment of a national board and a state board. It mandates that to establish appropriate authorities within 90 days from the commencement of the act by central government for union territories and state government for the states. So, that is section 35 requires that apart from the national board and the state board, appropriate authorities will also be appointed by the central government and the state government in accordance with their competent jurisdiction. Now, let us see the constitution of the Central Surrogacy Board. The minister in charge of the Ministry of Health and Family Welfare will be the ex officio chairperson of the Central Surrogacy Board. The Secretary of Government of India in charge of the department dealing with surrogacy will be the ex officio vice chairperson of the Central Surrogacy Board. So, the Central Surrogacy Board will have a chairperson, a vice chairperson and members. The chairperson will be the minister, the vice chairperson will be the secretary, and let us see who are the members of the Central Surrogacy Board. There will be 3 women who are members of the parliament who will be serving as ex officio members of the board. There will be 3 members of the ministries of central government of Women and Child Development, Ministry of Law and Justice and Ministry of Home Affairs. So, there will be 3 members who are nominated by the different ministries, which are the Women and Child Development Ministry, Ministry of Law and Justice and the Ministry of Home Affairs, and they should be not below the rank of Joint Secretary to Government of India. Then the next member is the Director of Health Services of the central government. Then apart from all this, there will be 10 expert members who are nominated by the central government, who will be experts in the field of medical and social welfare domain. The functions of the central board are given in section 25. The functions of the central board are: 1. To advise the central government on policy matters. So, with regard to all policy matters associated with surrogacy, the central government will be advised by the central board. They also have the function to review and monitor the implementation of the act. They also have the function to lay down the code of conduct for surrogacy clinics. they also have the function to supervise the functioning of the state boards. So, the functions of the central board are: 1. To advise the central government on policy related matters. So, with regard to all policy related matters associated with surrogacy, the central board will be advising the central government. They will also review and monitor the implementation of the act. Apart from this, they will also develop a code of conduct for surrogacy clinics who are operating in India, and they will also be supervising the functioning of the various state boards. Now, let us see the constitution of the State Surrogacy Board. The State Surrogacy Board will also have a chairperson, a vice chairperson and members. The chairperson will be minister in charge of the Ministry of Health and Family Welfare at the state level. The secretary of the Department of Health and Family Welfare at the state level will be the vice chairperson of the State Surrogacy Board. The members will be the Director General of Health and Family Welfare at the state level, then 3 women members from the State Legislative Assembly and the Legislative Council will be the ex officio members of the board. Then apart from all of this, there will be 10 expert members who are appointed by the state government, who will be experts in the field of medical and social welfare domain. The functions of the state board are given in section 26. The state board has the function to review the activities of the appropriate authorities functioned in the state. We have already seen that the state government at the state level will have to appoint the appropriate authorities for implementing the provisions of this legislation. The activities of appropriate authorities will be reviewed by the state board. The state board will also monitor the implementation of the provisions of the act. Then the state board will send consolidated reports to the central government regarding the implementation of this legislation. They will also undertake any other function which is prescribed under the law. Now, let us see what are the functions of the appropriate authority under section 36. Here we have to note that appropriate authority in union territories are appointed by the central government, whereas appropriate authorities functioning at the state level are appointed by the state government. Their functions are to grant, suspend and cancel the registration of surrogacy clinic. So, wherever there is a violation of the law is noted, the appropriate authorities has the function to grant, suspend or cancel the registration of the surrogacy clinic. They are also empowered to enforce the standards to be fulfilled by the surrogacy clinics. They will investigate on various complaints regarding the breach of the provisions of the legislation. They will take legal action either suo motu or on the basis of any complaint they have received. To suggest modifications to the national or the state board required in the rules and regulations is also an function of the appropriate authority. The appropriate authority shall also grant or reject applications for certificates for intending couple or intending woman who wants to act as a surrogate mother. Section 38 of the legislations deals with offences. Undertaking or promoting or selecting surrogate mother or engage intermediaries for commercial surrogacy is an offence punishable under the legislation. Advertising commercial surrogacy in any manner is also a punishable offence. Abandoning or causing to abandon or disown a child or children born out of surrogacy is also a punishable offence under section 38. Then selling human embryo or gametes for the purpose of surrogacy or running rackets for trading human embryos or gametes for surrogacy is also a punishable offence. Importing of human embryos or conducting of sex selection are also punishable offences under the legislation. The Act also gives in detail the penalties for contravention of the provision. Any person who acts in contravention of the offences mentioned in section 38 shall be punished with imprisonment which may extend up to 10 years, or with fine which may extend up to 10 lakhs. So, the offences under the Act are of very serious nature, that is why the punishment extends to 10 years and to fine up to 10 lakh rupees. If any registered medical practitioner is contravening the provisions of the Act, he will be punished with imprisonment for a term which may extend up to 5 years and with fine up to 10 lakh rupees. In case of subsequent or continuing offences the registered medical practitioner is doing, then his name shall be reported by the appropriate authority to the State Medical Council for suspension of the registration for a minimum period of 5 years. Of the regulatory framework. The introduction of arrangement of insurance for surrogate mothers during the pregnancy is another significant benefit of this legislation. This ensures that the medical needs of the surrogate mother will be properly taken care during the motherhood. The constitution of National Surrogacy Registry for the registration of surrogacy clinics ensures the safety and proper implementation of the surrogacy law in India. So, now we have seen the positive aspects of the legislation, but apart from all the positive aspects, there are some practical shortcomings also. Under the legislation, the couple means only legally married couples. Thus, the couples who are in a living relationship cannot avail surrogacy under the Act, and only men and women who are legally married will be allowed to become the intending couple. Thus, individuals belonging to LGBTQ community are not covered under this legislation. Many social activists are insisting that reproductive rights are part of the fundamental rights guaranteed under the Constitution, and so the provisions of this legislation should be extended to everyone. After the implementation of the legislation, so many interesting things have happened with regard to judicial approach to surrogacy law. I am referring to one case, Arun Muthuvel versus Union of India, before the Supreme Court in 2022. In this case, the central government had filed a clarification before the Supreme Court that the surrogate mother need not be genetically related to the child. As we had discussed, commercial surrogacy is completely prohibited under the Act. So, only a person with altruistic motive without any kind of commercial transaction will be eligible to become the surrogate mother. So, there was a view that only a person who is genetically related to the child can become surrogate mother. However, central government has filed a clarification before the Supreme Court stating that surrogate mother need not be genetically related to the child. So, a person who is not having any family relationship with the intending couple can also become a surrogate mother if it is purely based on altruistic motive. To conclude, India has a comprehensive legal framework for surrogacy under the Surrogacy Regulation Act of 2021 and its associated rules. The surrogacy law aims to balance the rights and interests of all the parties who are involved. This includes the intending couple, the surrogate mother and the surrogate child. The 2021 legislation have adequate provisions to protect the interest of the surrogate mother, including ensuring a medical insurance to the woman. The law also has adequate provisions to ensure that the surrogate child will not be abandoned and the interest of the baby will be protected. The Act effectively excludes certain sections of the society such as LGBTQ individuals, unmarried couple and unmarried woman from opting for surrogacy as a last resort of biological parenthood. The references of this lecture can be seen here. Thank you very much for listening to the lecture. I hope you are enjoying the course.